Oyez, oyez, the U.S. Supreme Court is now in session. We are here on only one case. All who have business before this court, please stand and be heard. Don't actually stand up. This is number 2014-2015, Andrea Somerville and William Denault, petitioners, appellants versus the State of Olympus, respondent appellee. Petitioners, are you ready to proceed?
Yes, Your Honor.
Respondents, are you ready to proceed? Ms. Russell, the lectern is yours.
Mr. Chief Justice, and may it please the Court, my name is Claire Rossell, and I, along with my co-counsel Ben Williamson, represent the petitioners in the case at bar. I'll be addressing Ms. Andrea Somerville's 14th Amendment challenge, and my co-counsel will be addressing Dr. William Denault's First Amendment challenge. Before proceeding, I'd like to request 3 minutes for rebuttal.
It is so reserved.
Thank you, Your Honor. I ask this Court to reverse the ruling of the 14th Circuit and hold that Proposition 417 unconstitutionally violates the 14th Amendment, and I ask this for 2 reasons. First, Proposition 417's ban on private insurance companies from covering the ultrasound procedure rises to the level of an undue burden. And second, Proposition 417 lacks the requisite health exemption necessary for abortion regulations.
Let's talk first about the point 2, your health exception. On what do you draw this notion that there is no health exception?
Your Honor, specifically looking at Section 3 of Proposition 417. Specifically in Section 3, there are 4 exemptions that are laid out there. First, an exemption for if the woman was pregnant due to rape or incest. Second, if the woman was a minor. Third, if the fetus has an irreversible medical condition. And fourth, for the preservation of the life of the mother. However, absolutely nothing in Section 3 can be construed as a preservation of the health of the mother. However...
So, counsel, besides the health exception, there actually is no abolition of abortion in the state of Olympus, correct?
Your Honor, there is no abolition of the...
So where's the undue burden, counsel?
Because, Your Honor, specifically, it is placing a substantial obstacle in the path of a woman seeking an abortion, particularly with the health exemption, that's placing an obstacle in the path of a woman by interfering with her decision to have an abortion. Now, Roe v. Wade and also Casey and Stenberg v. Carhart specifically noted that a medical exemption is necessary where it is within the appropriate medical judgment of the woman's physician, both for the preservation of her life and for her health. And this applies to 2 areas. First of all, Casey noted that there is an exemption necessary where the pregnancy itself poses a risk to the woman. And specifically, Casey noted that the state may not interfere with a woman's choice when the pregnancy poses a risk to her health, and an abortion is the correct option for her.
Okay, counsel, understanding the health exception, and I don't disagree in point, is there anything that you can point to the proposition in 417 that also constitutes an undue burden, besides the health exception?
Well, certainly, Your Honor, the ban on private insurance companies from covering the ultrasound procedure.
Is it an absolute ban?
Once again, Your Honor, could serve as an absolute ban for some women who are unable to afford the ultrasound, which the state is mandating.
My understanding of the law is they ban insurance companies operating in Olympus. There's no ban outside of the state of Olympus.
Well, certainly, Your Honor, and if a woman has insurance within the state of Olympus, she has to pay out of pocket for this medical procedure.
Okay, counsel, I understand that. So I understand the health exemption and health insurance, but where else can you look at in Proposition 417 where you can clearly show that there's an undue burden? Is it issues with the procedure? Is it the process? Where else is there an undue burden?
And throughout the proposition, also in the requirement that the woman see the same physician, and absent the same physician being available for both the ultrasound and the abortion, she must undergo the transvaginal ultrasound procedure up to 3 times.
Counsel, but let's walk through that. Okay. Do you agree that this procedure is invasive?
Your Honor, it's certainly potentially invasive.
Do you agree that abortion is a very serious decision and there must be a good relationship between a patient and her physician?
Certainly, Your Honor, that was recognized in Roe versus Wade.
Okay, so what about this possible argument that the state Olympus has chosen this requirement to foster that relationship between a woman and her doctor, so that the same doctor is performing that abortion?
Well, Your Honor, the state may have a preference that she have the same doctor perform both the transvaginal ultrasound and the abortion itself. However, if you combine this requirement with all the other requirements of Proposition 417, here's a hypothetical example that could occur. For example, a woman has a psychological condition which causes the transvaginal ultrasound to be traumatic to her. There's no health exemption. Further, she has private insurance within the state of Olympus.
So,
and
Counselor, let me interrupt you there. how is the transvaginal process any less intrusive or more intrusive than the actual procedure? So if the transvaginal ultrasound is used and it might create some kind of a psychological reaction, wouldn't the abortion procedure also do that?
Well, Your Honor, two responses. First of all, as far as whether or not it's more intrusive than the actual procedure, the state cannot presume that a woman, by forcing a woman to undergo a transvaginal ultrasound procedure, would basically cause the same psychological damage. And this is maybe even the equivalent of saying consensual sex versus rape itself. It's a question of consent. If you're forcing this invasive procedure upon a woman when she does not want it, that's where the violation is. And when she's wanting...
Counsel, that may go a little far. Couldn't a woman just seek an abortion in another state?
Your Honor, she could, but the state is still burdening by her decision by placing a substantial obstacle.
No, I understand that, but the sex and rape example, I mean, that's no one is involuntarily performing this procedure on any women here.
If she wants to have the abortion within the state of Olympus, then they are forcing this procedure upon her.
Can you talk briefly about what an undue burden is?
Yes, Your Honor. In Planned Parenthood versus Casey, an undue burden was designed as a state regulation which has the purpose or effect of placing a substantial obstacle in the path of a woman seeking an abortion. And Proposition 417 clearly does this.
Let's go back to Roe briefly. Can you break down the trimester framework for me in Roe?
Certainly, Your Honor. The court in Roe versus Wade recognized that the trimester framework was a helpful framework at understanding the state's interest in both the life of the unborn child and the health of the mother. And specifically, it held that there could be no regulation within the first trimester. Within the second trimester, the state did have a little bit more of an interest in at least regulating the abortion itself, the abortion procedures and the situations around the abortion. However, in the third trimester, the state could have an absolute ban on the abortion itself, and that was the fact pattern that arose in Roe versus Wade.
One other thing about Roe. Early in the decision in Roe relied on 5 historical sources for the woman's right of abortion, and they were ancient attitudes, the Hippocratic Oath, common law, English statutory law, and American law. Can you comment on the treatment of abortion before the 14th Amendment was enacted?
Well, before the abortion, sorry, Your Honor, abortion in some states was banned before the 14th Amendment, and so it depended on a state-by-state basis. There was no clear constitutional right to an abortion before Roe versus Wade. However, the court did rely on historical precedent throughout the Roe versus Wade decision. Now, Your Honor, as I was stating before, the cumulative effect of each of the undue burdens placed upon a woman through Proposition 417 shows that it is clearly unconstitutional.
Counsel, I can see where you're going clearly constitutional, but let me ask you this. Doesn't the state have an interest in preserving life?
Yes, Your Honor.
Doesn't the state have an interest in regulating the medical profession?
Yes, Your Honor. However,
well, in this case, isn't that what they're doing with the law?
No, Your Honor. Particularly in Planned Parenthood versus Casey, the court noted that the state's interest in life and their regulations that they're using to advance this interest must be designed to inform and not hinder a woman's decision. However,
but isn't that what the script is then doing?
Your Honor, the script may be informing her of some possibilities of risks, but the undue burdens are arising particularly from the ban on private insurance, so she's having to pay out of pocket, by the requirement that the same doctor perform both the ultrasound and the abortion itself, and the lack of a health exemption.
Have we ever, it seems like you're trying to put all the burdens in a blender and see if it adds up to the undue burden standard. Have we ever done that?
Your Honor, in Planned Parenthood versus Casey, there were several things, especially the spousal notification regulation, which showed that there was an undue burden.
Right. I'm sorry, go ahead.
There is no particular case that addresses the cumulative effect. However, each and every one of these regulations poses an undue burden, and especially when we view it in the cumulative effect of Proposition 417, we can see that it clearly poses an unconstitutional.
Just to be clear, though, doesn't Casey undercut that? Because Casey took discrete portions of the statute and decided that one section was unconstitutional while other sections, such as informed consent, were permissible.
Your Honor, I see my time has expired. May I briefly answer your question?
Yes.
Your Honor, Casey basically overruled one particular part of the rule that was the statute that was being questioned. However, Your Honor, as we've already shown, Proposition 417 is unconstitutional on several levels, and therefore the entire law should be ruled as unconstitutional. Thank you, Your Honor.
Thank you.
Thank you, counsel.
Mr. Williamson.
Mr. Chief Justice, Your Honors, and may it please the Court. My name is Ben Williamson, and I also represent the petitioner in today's case. Now, I'll be asking this Court to overturn the ruling of the 14th Circuit and rule that the State of Olympus acted unconstitutionally when it chose to enforce Proposition 417. And to this end, I'll be offering the Court two arguments for review. First, Proposition 417 fundamentally alters the traditional doctor-patient relationship. And second, the State of Olympus has failed to show that the information contained in Proposition 417 is both truthful and non-misleading.
Counsel, how does it fundamentally alter the patient-doctor relationship?
Yes, Your Honor. It boils down to this simple point. Proposition 417 restricts doctor speech and activity to such a degree that it prevents a doctor from giving his patient the adequate care or advice that the doctor believes the patient needs.
Right,
Well,
counsel.
by that logic, then how do doctors get sued for malpractice? Certainly there are regulations on poorly performing doctors, no?
Absolutely, Your Honor, but some autonomy does have to be left up to the doctor to determine exactly what his patient needs in an individual case. And as applied to this case, it could work out such as this. Proposition 417 contains no exception for the mental health of the woman. The state requires, to provide some background, the state requires Dr. Danoff and all practicing physicians to read a script to their patient that details the harms associated with the transvaginal ultrasound and abortion. And furthermore, the doctor has to describe the images on the ultrasound in detail. Now, Dr. Danoff, say Ms. Somerville walked into Dr. Danoff's office, and Dr. Danoff could see that Ms. Somerville, by a preponderance of the evidence, was suffering from a state of emotional trauma, or that she was emotionally disturbed. Dr. Danoff, even if he believed that reading her the script and showing her the images in detail would damage her psychologically, Dr. Danoff, under Proposition 417, would still have to do all of that, even if he believed it wasn't in the best interest of his patient.
What would you say, though, to the argument that the state considers the harm that would be done to Ms. Somerville as worse if the abortion is performed and she realizes later there were consequences she did not foresee, rather than telling her the unfortunate consequences she's about to foresee?
Your Honor, that's something that this court actually addressed in Planned Parenthood versus Casey. And they said that the state can go to a certain extent in requiring the doctor to give certain information for informed consent.
But isn't that what they did here with the script?
No, Your Honor, because they went beyond what Planned Parenthood versus Casey allowed. What Planned Parenthood versus Casey said was that it is constitutional for a state to require doctors to disseminate certain information for the goal of informed consent. But under that case, the court said that there must be an exception or some leeway for a doctor to use his autonomy to determine what is best for the patient. And the goal of that was to prevent the state from attempting to sort of use a one-size-fits-all for every single patient.
So, counsel, are you trying to argue that we should substitute the doctor's choice for the patient's choice?
Absolutely not, Your Honor. The patient is ultimately what's at concern here. At no time would petitioner ever argue that a doctor should force a patient to do anything subject other than what is in state law. Now, we're not saying we should subject the patient's or substitute the doctor's decision for the patient's decision. If the patient believes that she is emotionally ready to see the images on the screen, or if she believes she's emotionally ready by preponderance of the evidence to hear the script, then the doctor should do that.
But counsel, to take your point logically through to its conclusion, if the doctor has a concern about the mental well-being of the patient, then wouldn't it be fair to say that the doctor would have to make a decision on behalf of the patient?
That's true, Your Honor, but he's not making a decision for the patient. He's just making a decision on behalf of the patient with the patient's input and consideration. The difference in this case is that neither the patient nor the doctor has a choice.
Well, let's talk about Section 11.
Yes, Your Honor.
Section 11 does permit medical judgment does permit medical judgment about whether to obtain an abortion. Do you agree with Gonzalez that we should interpret apparently conflicting statutory provisions in such a way that they are constitutional if possible?
Certainly, Your Honor, but...
Okay, so if that's the case, why don't we interpret it this way? Yes, Rule 3 says do not pass judgment on the propriety of abortion. Generally, your own opinions, your own ideologies. But Section 11, you may give directed, pointed, individual advice to Ms. Somerville.
Certainly, Your Honor, and the court touched on the idea of reading a statute as constitutional unless otherwise noted in both Hurley versus Irish American GLIB and in Nelson versus Patrick as cited in Florida Bar versus Wentford. But those same cases ruled that courts shouldn't read things into statutes that aren't there.
What was the government's interest in Florida Bar?
In Florida Bar versus Wentford, it was to protect privacy of individuals, Your Honor, because in that case it was dealing with a law firm that was sending targeted advertising to participants that had suffered death or injury within a 30-day period. So the interest was to protect privacy. And what we see here is the state attempting to advance that same interest, but they're doing it in a way that's overly extensive.
Well, how is it overly extensive, counsel?
Your Honor, because the doctor is not allowed to give advice that the patient believes they need, nor is he allowed to make a judgment based on the patient's emotional state.
Can you point to anywhere in the facts where that has actually occurred, where he didn't give advice?
Absolutely, Your Honor. First of all, Appendix 3, Rule 3, found on page 17 of the record, says that a doctor shall not comment on the legality of the law.
Well, I understand the rule, but can you actually point to anywhere in the facts where that took place?
Absolutely, Your Honor. Ms. Somerville actually asked Dr. Danoff to comment on some of the studies that the state says they have, and she asked Dr. Danoff to confirm the legitimacy of those. And Dr. Danoff was unable to answer that question.
And why was he unable to answer that question?
Because, Your Honor, the penalty for answering that question was a $10,000 fine and losing his medical license.
Well, counsel, my understanding is the reason he didn't answer those questions is because of advice of counsel.
Yes.
So I proffer the question to you. What if counsel is wrong? Should we strike down a state law because several attorneys or additional counsel was incorrect in their interpretation of the law?
No, Your Honor. It wouldn't be simply for that reason. We're just asking the court to read what's there in the law. And Proposition 417 does not give a doctor adequate leeway to give advice.
Do you feel that the script is factually incorrect, misleading, or scientifically wrong?
Not necessarily, Your Honor, but there is some information in the record that indicates that it could be, and thus the burden is on the state to prove that it's not. Now, in order for a doctor to be required to say something, Florida Bar versus Wentford ruled on commercial speech, as did Central Hudson, that said that any lawful speech has to be associated with a commercial enterprise and must be truthful or non-misleading. Now, Central Hudson said...
Just to be clear, that's the test to determine whether commercial speech is protected, correct?
Yes, Your Honor. And Central Hudson said specifically that it is the state's burden, the state's responsibility to show that an information they require a doctor or a professional to disseminate is accurate, truthful, and non-misleading. And the state has not done that in today's case.
Do you dispute? Let's go to Appendix 2.
Yes, Your Honor.
Can you point me to any provision of the script that is not truthful? Let's start there.
Your Honor, I see my time is briefly about to expire. May I answer your question?
I'll shorten my question. Can you point to any section that is either not truthful, misleading, or is not relevant?
Your Honor, to answer your question sort of directly, the contention that petitioner has is that there are several sections in the script that are disputed, and thus it's the state's responsibility to prove those. And one of those could be that you may suffer from a lifetime of guilt, or that you will suffer from violent tendencies, that you could be a danger to yourself and to others. Those three examples are all in the script, and they're disputed by the medical community. Thus, it's the state's responsibility to present the information they use to come up with that script, and it is found nowhere in the record. Thus, Proposition 417 falls short of the test in Central Hudson, and for that reason, we'd ask this court to reverse the decision. Thank you, Your Honor.
Thank you, Mr. Williamson.
Thank you, counsel.
Ms. Thompson.
Mr. Chief Justice, Your Honors, and may it please the Court. My name is Andrea Thompson, and today I, along with my co-counsel, Ms. Emily Sawicki, rise on behalf of the respondent, the state of Olympus, in the case at bar. I will be addressing the 14th Amendment issues, while my co-counsel will be addressing the First Amendment issues. The state of Olympus, Your Honors, finds itself today in the difficult position of defending a government regulation of a constitutionally protected liberty interest. While the state concedes that such regulations are typically plagued with disapproval, the state of Olympus finds itself today in a truly unique position. Namely, because Proposition 417 was carefully crafted by the people of the state of Olympus and voted in as a public referendum.
Well, was it crafted by them? I thought it was crafted by Senator Manners and Representative Lyles.
Yes, Your Honor, it was crafted by Senator Manners and Representative Lyles. However, each of those senators was embodying the interest of their constituents, and thus Proposition 417 represents the interests of the constituents while also balancing important government interests and staying within the bounds that have been established by this court.
28 state legislatures in Stenberg thought that DNX was not appropriate, and we said, sorry, it doesn't matter what the state legislatures thought.
Yes, Your Honor. However, the case we have today demonstrates that the people of the state of Olympus felt that the values embodied in Proposition 417 were important, and thus it brings us here today. Proposition 417 is constitutional because it does not have the purpose or effect of placing a substantial obstacle in the path of a woman's right to choose.
Counsel, let's talk about substantial article. Can you tell me what exactly is the procedure right now when a woman comes to an abortion clinic? From the minute she walks in to the moment she has an abortion, what is the procedure?
Your Honor, after the woman has consulted with her physician?
When she enters the clinic?
Yes.
What happens? There are multiple steps within this law in order for her to get from point A, which is entering the clinic, to the last point where she has an abortion. What are those steps?
Per Appendix 1, Section 12, the woman is required to pay for this procedure herself, and then she enters the clinic. She is read a speech by her physician. She is required to sign a consent form, and then she undergoes a transvaginal ultrasound where she is presented with a sonogram of her fetus.
I'll let you get back to answering that, but just briefly.
Yes.
Are all insurance companies barred from covering all procedures, or just all procedures that don't fall under the exceptions in Section 3?
Yes, Your Honor. Counsel misspoke. The latter,
Okay.
yes. And she is presented with a sonogram of her fetus. She is required to listen to the heartbeat, to view the fetus, and then after that she has to wait 24 hours, and then she can come back.
So that's quite a substantial procedure, wouldn't you agree, Counsel?
It is a substantial procedure.
So if you were to consider in the totality, how is that not an undue burden?
It is not an undue burden, Your Honor, because an undue burden, as established in Casey, was one which has the purpose or effect of placing a substantial obstacle in the path of a woman's right to choose.
Can I add one step to, I agree with your recitation. Let's add one step. The woman comes back, and her doctor's not there.
Yes.
She wants to get the abortion, but she can't.
Yes.
She has to undergo another transvaginal ultrasound.
Yes.
And then 3 more days go by and she comes back.
Yes.
And the doctor's still not there. She has to go get a 3rd transvaginal ultrasound. The doctor's still not there. Finally, 3 procedures and possibly 2 weeks later she gets the procedure. Isn't that kind of, the fact there's 3 tests kind of add to that burden, which my co-justice asked you about?
Respectfully, Your Honor, the respondent would contend that yes, this does to some extent amount to an obstacle. But what the court needs to consider today is whether or not this obstacle rises to the level of substantiality that was condemned in the 1992 case of Planned Parenthood versus Casey.
Can we take a step back? I asked Marcel this question, and I'll ask you about Roe. Roe talked about a number of historical sites for the right of abortion. Can you comment on the treatment of abortion before the 14th Amendment was enacted, either in America or Europe or both?
Just in general?
Yes.
Abortion, as you mentioned, Roe discussed the different societal opinions of abortion. However, a majority of what Roe cited was that abortion was not commonly recognized by society, and Justice Rehnquist's dissent in Roe actually pointed out that the right to an abortion is not so recognized as the petitioner would have us to believe.
Would you agree, though, that there is discussion that pre-viability abortions were at least criminalized less than post-viability abortions. Is that a fair assumption?
Yes, Your Honor, and that was embodied in the Roe decision when they established the trimester framework. However, Casey overturned the trimester framework because they felt that in the first trimester there were instances where state interests needed to be balanced that were not incorporated into the Roe trimester decision, which to some extent forbid many important state regulations that would fall into that category.
Can you run me? Sorry.
Oh, sorry. Can I inquire, I think along that framework, what is the purpose of the transvaginal ultrasound versus the transabdominal ultrasound? Why does it have to be so invasive at this point? Does it go to viability?
No, Your Honor, it is not about viability. If we look to Addendum 1 of the record, we will see that the transvaginal ultrasound can provide the clearest picture and therefore most information for women at the earliest stages of pregnancy.
What information are we looking to provide, though, at that point?
At that point, the purpose of the transvaginal ultrasound is to provide the woman with a clear picture of the fetus that is growing inside of her. And in many cases, a transabdominal ultrasound would not be sufficient, especially at the earliest stages of pregnancy.
Wouldn't it be safe to assume, though, that if a woman is seeking an abortion to begin with, that the difference of a clear picture versus a less clear picture is not going to make that much of a difference to the point where the transvaginal ultrasound should not be mandated because it is quite an invasion of privacy for that woman?
Yes, Your Honor. Although there might be cases where a transvaginal ultrasound is unnecessary, it is important for us to consider that this is not a case of strict scrutiny, and thus the government's measures here need not be the least restrictive means necessary in order to achieve their goals. Per the definition in Casey, there only needs to be a reasonable means of achieving a legitimate ends.
I agree with you about your discussion, and I see in Addendum 1 that transvaginal ultrasounds provide images during the first trimester that may not necessarily be fully seen by a transabdominal ultrasound. Does this law only apply to first trimester abortions? By its own terms, it appears to apply to all abortions.
Yes, Your Honor, it does apply to all abortions.
So it applies to a situation where its own addendum does not suggest that a transvaginal ultrasound would provide more information than a transabdominal ultrasound.
Yes, Your Honor, it does not suggest that. However, as Your Honor mentioned earlier, the transvaginal ultrasound is arguably no less invasive than the abortion procedure itself, and furthermore is a common medical procedure which many women are forced to undergo once they become pregnant in order to receive women about their
What
fetus.
is your authority for that proposition?
Excuse me, Your Honor.
A case or fact pattern authority, the notion that transvaginal ultrasounds are common procedures?
Transvaginal ultrasounds, according to the record, are required in order to obtain an abortion in at least 11 states already, and thus there is some precedent for this sort of requirement in state
Well,
regulations.
counsel, if I could just bring to your attention one more time about undue burden.
Yes.
What happens if a woman seeking an abortion lives 100 miles away or more than 100 miles away? We're talking about a 200-mile-plus round trip. How's that not an undue burden?
Respectfully, Your Honor, respondent would contend that is not an undue burden simply because the purpose of Proposition 417 is not to place a substantial obstacle in the path of a woman's right to choose, and the effect in that case...
But does the law allow for any exemption for someone who lives 100 miles away?
No, Your Honor, it does not, simply because to place an exception for a certain distance that a woman lives away could in some sense require an arbitrary number. You know, what constitutes a substantial obstacle there? 100 miles, 50 miles, and thus by...
Well, counsel, I'll call to your question Section 9 of Appendix 1, where it says this provision can be waived if a woman certifies in writing that she currently lives 100 miles or more from the nearest licensed abortion facility. But let's bring it closer. Let's say she lives 80 miles away.
Yes, Your Honor.
So now we're talking about a 160-mile round trip. As my co-judge mentioned earlier, let's say the doctor's not there. She has to come back. That's a second time. Now that's 320 miles. How about a third time? That's now 480. Over almost 500 miles in travel, potentially, if she was 80 miles away. And I'm just picking a number to pick a number, but how is that not an undue burden?
Your Honor, that extent of travel definitely would be considered to be an obstacle. However, what the state is attempting to do here is balance its interest for maternal health and protecting the life of the unborn with their interest for the women to be as informed as possible. By requiring a woman to receive the ultrasound to be the same woman that completes the abortion procedure, the state is promoting women's health by ensuring that the physician that gives the woman the abortion is the one that has the most information possible about her pregnancy, and thus this directly serves to promote the government interest of promoting health.
Just briefly, counsel,
Yes.
how long does it take to undergo a transvaginal ultrasound?
According to the record, it takes 30 to 60 minutes.
And in this case, how much time passed between Ms. Somerville's first consult with Dr. Denal and the transvaginal ultrasound?
I believe it was 5 days, Your Honor.
Thank you.
And it is for these reasons and the aforementioned reasons that respondent urges the court to uphold the decision of the lower court. Thank you.
Thank you, counsel.
Ms. Sawicki.
Mr. Chief Justice, Your Honors, and may it please the Court. Good afternoon. My name is Emily Sawicki, and I represent the respondent in the case at bar, the state of Olympus, arguing that Proposition 417 does not violate the free speech rights awarded to licensed physicians in the state of Olympus under the First Amendment to the United States Constitution for 2 main reasons. First, the regulations on the speech of professionals, the physicians in this case, falls under the regulatory powers of the state. And second, even if the regulations on the speech of the physicians did not fall under the regulatory powers of the state, Proposition 417 does in fact concern commercial speech.
Well, counsel, let's talk about regulatory powers. I'll ask you similar questions as I asked opposing counsel. I think it'd be fair to say that a state has an interest in the regulation of the medical profession. Would you agree with that proposition?
Of course, Your Honor.
Okay, well then let me ask you this. Wouldn't it be fair to say that a doctor acting within the scope of their responsibilities as a doctor have an independent medical opinion or render an independent medical opinion when they're consulting a patient?
Of course, Your Honor.
Then isn't it the possibility with this script, if they don't agree with it, that you could be interfering with the independent medical judgment of a doctor?
No, Your Honor, it is not. Proposition 417 allows physicians to give medical advice on whether or not to obtain an abortion.
Right, but Rule 3 also says that if you don't follow these rules in your physical license, the Department of Public Health can take away your ability to practice. In fact, it's also mentioned in Section 11. Actually, I'm going to correct myself here, not Rule 3, but specifically in Section 11, that if a physician fails to comply with this law the first time, they're fined $10,000. If they do not comply in excess of 3 times, they are subject to the loss of their license. How is that not compelling speech? How is that not interfering with the professional, independent judgment of a doctor?
Well, Your Honor, it is because they are not compelling the content of their speech, rather their conduct as professionals.
Well, let's be clear, though. I mean, okay. Let's talk about pickup. Pickup concerned, let's talk about pickup. Can you walk me through it?
Sure. In Pickup versus Brown, there was a medical procedure which was given, and the procedure itself had to deal with speech. And when giving a speech to patients, the idea was to try to get them to change their sexuality. In this case, it's actually very similar to Pickup, in that while the physician is required to give a speech, the speech itself is actually in the conduct of the professional.
Right, but in Pickup, there's a discussion of talk therapy, for example, as a treatment. But there, the talk therapy is the treatment. No woman is receiving an abortion because a doctor read a script to her. It's a separate medical procedure. The transvaginal ultrasound is a separate medical procedure. So would it be fair to say that Pickup this is unlike Pickup in that the speech is not incidental to professional conduct?
No, Your Honor. Respondent contends that it is actually very similar to Pickup, because while the speech that physicians give women before the transvaginal ultrasound is different from the transvaginal ultrasound procedure and the abortion procedure, it is like a procedure itself, because Proposition 417 establishes it as part of the doctor's conduct when dealing with a woman who's considering an abortion.
Why is this case not analogous to Conant?
This case is not analogous to Conant because it was found in Conant versus Walters that prohibiting doctors from telling patients to use medical marijuana as a perhaps treatment did not actually make the patients violate the law and purchase marijuana illegally. In this case, physicians...
Well, it encouraged them, didn't it?
Pardon, Your Honor?
It encouraged them to violate the law, didn't it? By recommending marijuana.
Well, the difference here, Your Honor, is that physicians themselves would be performing the abortion procedure. They're not also selling marijuana, as the physicians in Conant versus Walter weren't also selling marijuana.
We certainly hope not.
Yes. So my point, Your Honor, is that it's 2 different things. So here the physician is trying to get a woman to decide whether or not she should obtain an abortion, if it's the right medical procedure for her, using his medical knowledge, which he is allowed to give under Proposition 417.
Let's talk about commercial speech. Can you tell me what commercial speech is?
Yes, Your Honor. We can look to Central Hudson to find that commercial speech is speech that deals with the economic interests of the speaker. But that definition
Just
goes...
the speaker.
No, Your Honor, the speaker and his audience, and that definition goes on to say that commercial expression not only serves the economic interests of the speaker, is assisting consumers in furthering the societal interest when providing information. That information can still be considered commercial speech.
Okay, so let's take it a step further. Can you parse through, do you agree with me that not all commercial speech is protected speech?
Yes, Your Honor.
For example, if I offered money to threaten to kill someone, that would be commercial speech because myself and the audience to whom I was speaking are economically interested, correct?
Yes, Your
But it
Honor,
would certainly not be protected.
because it concerns unlawful activity.
So what is the test for protected commercial speech?
So the test for protected commercial speech can be found in Florida Bar versus Wentworth Incorporated, which expands upon the test that was established in Central Hudson. In Florida Bar versus Wentworth Incorporated, we can see that for speech that does not concern unlawful activity and is not misleading is permissible if the government first asserts substantial interest.
So, counsel, let me ask you, how is it not misleading if the state's only giving one side of the argument and not allowing for the other side to be fully vetted?
Your Honor, I can answer your question on 2 points. First, it's not misleading because it only gives one point of view, because the state deems that the point of view it should be giving when women are seeking an abortion are the risks and benefits that are associated with abortion. Giving women the risks and benefits associated with pregnancy would be a moot point here, because she's interested in what happens if she obtains an abortion.
The fact that you used the word, the point of view the state wishes to give, that sounds like a viewpoint-based restriction. Haven't we held that such restrictions are subject to strict scrutiny?
Well, Your Honor, we can look to Planned Parenthood of Southeastern Pennsylvania versus Casey to see that the state does have a compelling state interest in wanting a woman to choose childbirth over abortion.
But wouldn't it be fair to say that the script in a way is ideological? That could also be construed as a viewpoint.
No, Your Honor, and that brings me to the second point to answer your question, Your Honor.
Well, counsel, but I want to call to your attention right in the script, and I will read this sentence for you. Parenthood can be a rewarding and wonderful experience.
Yes, Your Honor.
Sounds like ideology, sounds like a viewpoint to me.
It is a viewpoint, however, it is not a particular point of view. We can look to Woolley versus Maynard to see that ideological speech is speech that portrays a particular point of view.
What was the speech at issue in Woolley?
In Woolley, there was a man who did not want to have the New Hampshire state motto, "Live Free or Die," displayed on his license plate, and it was determined that he did not have to have that displayed on his license plate.
Why didn't he want to display it?
Because he did not agree with the motto, Your Honor. And he did not have to display it because he was acting as a provider for the state's message. However, the difference here is that physicians are acting as professionals. They're not acting as citizens. The state in Proposition 417 is certainly not trying to limit physicians' opinion on abortion and how they give it to people outside of the medical profession.
You got cut off when you were talking about the elements. Can you take me back through the rest of the Central Hudson elements after substantial interest?
Of course. And I would first like to assert that,
Sure.
to your question, that it's not misleading because we can look to rounds to see that the information given in the script here actually is factual information that most of the medical community agrees with.
Most, right, except for the out-of-state oncologist with whom Ms. Somerville spoke, counsel.
On any point of opinion, Your Honor, there will always be people that agree and disagree. And we have no information to suggest that the out-of-state oncologist holds the opinion that all medical personnel hold. But we can look to rounds to see...
Then how do you square that with Stenberg? Because in Stenberg, 28 states said, we want to ban this procedure. And we said, we don't care what your medical opinion is, the procedure is permitted.
Well, Your Honor, we can also look to Stenberg to see that the risks and benefits that are, the risks that are associated with abortion are equal to the physical risks that are associated with pregnancy. A woman is just as likely to suffer physical harm from her pregnancy and going through childbirth as she is with an abortion. So the state showing a woman the risks associated with abortion here actually is not showing her any type of non-factual information.
One other question. Is this law vague?
This law is not vague, Your Honor.
What is the test for vagueness?
I'm sorry, Your Honor, I do not know the test for vagueness. Now continue to the points for Central Hudson that establishes for the commercial speech test, The first point is that the state must have a substantial state interest. The second point is that the regulation must directly and materially advance that interest. And the third point is that the regulation must be narrowly drawn. Now this prong is different from the narrowly tailored test that we find in strict scrutiny, because as we find in Florida Bar, it just means that there must be a good fit between the alleged interest of the proposition and the actual interest served.
What was the speech at issue in Central Hudson?
The speech at issue in Central Hudson was that an electric company wanted to advertise the use of electricity.
How about Con Ed?
And Conant, the speech in question was that a electric utility company wanted to include pamphlets in its bills that promoted ideas that not all people that were receiving the bills agreed with and were not related to the bills. I don't remember, Your Honor, but I remember that they were not related to electricity itself. I believe they were political ideas.
Okay, thank you.
So to continue, Proposition 417 passes the Central Hudson test because there is a good fit between the alleged state interest and the actual interest served here. And we can look to Casey to see that there is also a compelling interest. And it's for that reason and the aforementioned reasons that we ask that you uphold the decision of the lower court and rule in favor of respondent. Thank you.
Thank you, counsel.
Thank you, Ms. Sawicki. Mr. Williamson.
Thank you, Chief Justice, and may it please the court. Petitioner respectfully submits 2 points of rebuttal. The first is that Proposition 417 lacks the necessary exceptions to allow doctors to adequately care for their patients. And the second is that the state has still failed to prove that the information that Proposition 417 requires doctors to give is both truthful and non-misleading. We'll begin with the first point regarding whether or not Proposition 417 allows doctors to adequately care for their patient. And Your Honor, what we can see from what's been brought up throughout today's proceedings is that Proposition 417 simply doesn't have the exceptions that doctors need to fully care for their patients. That's what this court explicitly ruled on in Planned Parenthood versus Casey, is that in order for a state to require a doctor to give certain information to a patient, there must be exceptions to allow a doctor autonomy to determine what is best for his patient.
Is that what Casey said, or are you drawing a negative pregnant from Casey? I'll explain. In Casey, yes, there were exceptions which allowed for medical judgment. Does that mean that if there isn't one, that it's unconstitutional?
Yes, Your Honor, it does, because in Casey the court ruled that those exceptions were key in preserving the relationship between doctors and patients.
Counsel, isn't it just your point that you just made, though, about lacking the exceptions, and going back to the argument, or the example I think that you put forward in your first addressing of us, when you said that if a woman came and it was going to be emotionally traumatic for her to have the ultrasound, or if she had mental health issues when she came in, isn't it just as good for the doctor who was presumably an OBGYN to look at that person and say, okay, there's a whole nother set of issues going on here that have to be referred to a specialist. I shouldn't be taking this on anyways, so I'm going to, I guess, exercise my discretion and just make you aware of your options to go see a mental health professional or somebody else that could better address other concerns not related to your pregnancy? Doesn't that still give him the same opportunity?
Well, of course, Your Honor, but Proposition 417 doesn't allow for that. And the reason is because it's so...
For a referral?
Well, it only allows a referral to the State Department, Your Honor, because no licensed physician in the state of Olympus can comment on any of the things that Dr. Denolf wanted to comment on. He has to refer her...
Let me ask you this question.
Yes, Your Honor.
Let's talk about point 2. I don't mean to cut you off there, but let's talk about point 2. Could Dr. Denolf take this paragraph, write his own paragraph about the risks of childbirth, and present both of them to a patient and follow this law?
No, Your Honor, he could not.
Why is that?
Because he is not permitted to add his own advice or judgment, medical or otherwise, on Proposition 417 or the studies it contains. And that's found on page 17 of the record in Appendix 3.
No, I agree with that. But what if he just said the risks of childbirth include and listed them and left it at that, listed no studies and said nothing about the previous paragraph? Would that violate the statute?
It would, Your Honor.
Why is that?
Because he does, and I see my time has expired. May I answer your question, Your
Yes.
Honor? It would violate the statute because it doesn't give Dr. Denolf or any other physician the chance to omit certain statements if they believe that the psychological health of their patient will be damaged. That's explicitly what this court required in Casey, because the doctor-patient relationship is sacred. The patient has to be able to trust the doctor to do what's best for them medically, and Proposition 417 doesn't allow for that. Your Honor, having answered your question, may I briefly conclude?
Yes, briefly.
For these reasons, Your Honors, we respectfully urge this court to reverse the decision of the lower court and rule Proposition 417 to be unconstitutional. Thank you, Your Honors.
Thank you, Mr. Williamson.
Thank you.
Please be seated. Ladies and gentlemen, this competition, you all showed such great preparation, your poise, difficult questions. You did a wonderful job, and you should be very proud of the job you did. This is about learning, and I can see the learning has happened here. That being said, this year's winner is the petitioners. Like I said, very much to be proud of. You know, we were all proud to sit and listen, and you make this a worthwhile experience for judges as well. And I thank you both for your time, for your efforts, and your preparation. Oyez, oyez, the U.S. Supreme Court is now in session. We are here on only